Yes,
Hello,
Smita. Can I
everybody.
start?
Welcome for this discussion of ours. This is March 2022, the Women's Day month. I hope you all had a lovely day on 8th of March and the celebration is continuing. So somebody was messaging saying that, okay, 8th March is over, so celebrations are over. I believe that we have to celebrate ourselves every day. And while there is a day specified for us, but we should be celebrating and living every day. So with that, I start this discussion, panel discussion on management and recommendations. This is primarily stemming up from a lot of organization understanding IC's role, employers' role, where do we overlap. So we're going to have this discussion today to see what we can understand from the paper, the law which is given, and what are the best practices. All right. So we, KelpHR and ILA does the session together. I have Madhura with me who will speak about ILA.
Yes, Smita. Thank you so much. So first of all, we are so proud to be associated with KelpHR now for more than a year. And Smita here is like, she has so much information, knowledge and experience about this field now. And we are like, as I said, very proud. So myself, Madhura, I represent Indian Lawyers Association. We are a pan-India organization working for the betterment of the legal professionals in the country. We primarily do this by way of offering a platform for the lawyers for education, mentoring, networking, and continuing their legal education by way of various discussions, events, and webinars. Some of our recent initiatives like the Legal Aid or the Students ILSA, Indian Law Students Association, which has been working as a platform for mentoring and guiding students and young lawyers. So this has been quite a rewarding experience for all of us at ILA. We have about 75 chapters in the country, and these chapters necessarily add a local flavor to the operations of ILA. So our website has all these details and the list of cities in which ILA is present. And I will be very happy to invite all of you to join ILA in your city. And if at all there is no chapter yet, please feel free to reach out to us. We'll be happy to start a chapter. Smita, thank you so much. Over to you.
Thank you so much, Madhura. I'm sure a lot of people are excited to know that. So a little bit quickly about KelpHR. We started in 2013. When we started in 2013, the law had just come in. And the reason why we started is because a lot of people, a lot of organization, employees, employers were confused about what is this law all about? How do we implement it? How many people we'll have to reach out to ensure implementation? So here we came in and we said that we would be able to simplify the whole aspect of this law. So we stepped in and we tried to simplify as much as possible. We have panel members of lawyers. We understand it from layman's language and further share it with employers, employees in this platform. So today, a little bit about myself. I have around 23 years of work experience total, and I'm the co-founder and CEO at KelpHR. PoSH has been something that I've been breathing from last 8 years since the law came in. And of course, I've been working during Vishakha times as well. Today, I have with me the eminent panel members. You can see Rashi Sinha and Swati Dubey. Quickly about them, I would want to share that Rashi is the founder of the Yellow Car company, which works with the organization to help them grow exponentially by working on two key areas, process and people, which leads to higher productivity. As a business productivity coach and corporate trainer, she has positively impacted over 15,000 lives over last 4.5 years. Rashi has more than 21 years of corporate experience, where her key mandate was to launch new business verticals and products with the responsibility to make them revenue success. She's an MBA from Sri Balaji University, Pune, and economics graduate from Delhi University. We have also our young Swati Dubey, a corporate a company secretary, law graduate, and master's in commerce, having experience of more than 7 years in corporates and legal firms. She has significant industry experience, majorly with listed companies, and guides clients on complying with various corporate laws and ensures that a company operates in accordance and legal provisions. She's also acting external member in the internal committees of various companies. Now, we thought that before we get into this discussion, there are stuff that we should be taking care of. We need to understand few aspects. First and foremost is, what is employer? I understand all of you all here on this panel who have been dealing with IC for a really long time understand who the employer is. But after dealing with 250 odd cases last 8 years, I have been going back to this definition again and again to understand this better. All right, so I'm going to highlight few aspects. Recently, I was dealing with one case where the senior most person in the organization was named as a respondent. At that point of time, we were trying to understand that is the complaint against the employer, can we now take this to LCC? So that is the time when we had to revisit the definition of employer. So just for our context of today's conversation, I thought it is a good idea for us to revisit. So I've highlighted few aspects here. So who's an employer? The head of that department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit, or such other officer. Okay. The second point is responsible for management, supervision, and control of workplace. Third point, management includes the person or board or committee responsible for formulation and administration of policies of such organization. Fourth point, the person discharging contractual obligations with respect to his or her employees. While all the points here are very, very important, but I thought it is important for us, for our today's discussion, to revisit these aspects. Now, what is the role of the employer? What we have done is we have gone through what is mentioned in the law. We've looked at some best practices organizations follow, and then taken a laundry list of what is the role of an employer. The role of employer is to ensure that we have PoSH policy. We have posters put up across the organization. Now, in posters, when the pandemic happened, not only physical posters, we were recommending organizations to also have soft or e-copies of posters on their website, or not only on their intranet, also on their internet. Because if somebody externally wants to file a complaint, where will they look up for? So putting up policies and posters. Constituting IC is definitely their responsibility, which includes appointment of external member. All right. Conducting a skill building, capacity building workshop for IC members is also employer's responsibility. Providing a safe working environment is employer's responsibility. Executing order of interim relief. Now, this comes during the case handling. So during the case handling, if there is an request from IC to give an interim relief, then execution of that interim relief is employer's responsibility. Securing attendance of witnesses during inquiry is employer's responsibility. Sanctioning expenses occurred during the inquiry process. For example, there is an infrastructure required to conduct inquiry. There are times when we cannot conduct the inquiry within office space because of confidentiality, and we use some external space. Then creating that external space, providing that external space becomes employer's responsibility. Recovering of sums for contravention of confidentiality. Many a time confidentiality is compromised. At that point of time, who will recover this becomes employer's responsibility. Implementation of recommendation, the outcome of the inquiry, implementation of those recommendations is employer's responsibility. Now, I would want to take a little pause here and also add that employer many times is played by HR, human resources, because they act as an employer. Okay, So very loosely we use the word employer stroke HR. Okay, so today itself I got one query from one of our clients who was asking me, Smita, the head of department, or sorry, the head of human resources, can that person be part of IC committee? I clearly mentioned that if the human resources head is also the employer, then he cannot be the presiding officer. Of course, it's she, so she cannot be the presiding officer. So there is this constant question. After 8 years down the line, also we get these questions, right? So that makes me feel that we have to keep speaking about this again and again and again. So not only HR head, also legal head should not be part of IC, because both of them have a basic requirement to protect the organization's needs. So there will be biases that will creep in. So we recommend that head of HR and head of legal should not be part of IC. Is it mentioned in law anywhere? No, it is not mentioned in law anywhere, but it is the best practice, or it is implied. I think Swati after a while can add if she wants to add anything to this aspect from legal perspective. You're on mute, Swati.
Absolutely correct, Smita. I wanted to just to second whatever you have said, that yes, there in legally it's never mentioned written anywhere that a legal head or HR head cannot be a presiding officer. However, in good corporate practices and good corporate governance law, this should not be the practice. So I want to just second whatever you have said.
Thank you so much. Rashi, do you have any inputs here, or I can proceed?
Absolutely not, Smita. I agree with both of you. So it is because when roles are defined and there are contradictions, in that case, it's always the safer environment for the employees that should become the priority. And such a person who has this conflict within the organization ideally should not be part of the IC.
All right. Thank you so much. So we've tried to make this list, Rashi and Swati, as exhaustive as possible. But during our conversation today, if you feel that we are missing on any roles of employer or IC, I'm going to speak about IC. And I also have a list where IC and employers have to work together. Okay, so I'll share these lists. And once we look at it, we could see if there needs to be anything needs to be added to it. Right. So I'm moving to the definition of internal committee. Clearly, if you saw employer's role, one of their important role is to constitute internal committee, right? Now, what is internal committee? Internal committee is group of internal as well as at least one external member. So internal committee will have a presiding officer, an external member, and few other members. So the presiding officer is generally the senior most person of that woman employee of that organization. Two other members could be with some background of handling work in the cause of women or children, and at least one person who's an external member. Again, there are few aspects to picking up the right kind of external member, and today is not that discussion. Maybe we'll take that discussion someday later. Out of this composition should at least have 50% or more women in that in IC, internal committee. So if we have 5 members, at least 3 should be women and 2 could be others. Okay, so this is very important. And now moving to the role of IC. IC during the complaint or during the proceeding, IC receives the complaint. A grant of interim relief, granting the interim relief to the complainant during the proceeding is IC's role. Summoning parties for hearings or meetings is IC's role. Now look at this. There is a little bit of overlap here. While summoning is IC's responsibility, but lining them up for witnesses is employer's responsibility. So there is a thin line here. Okay, you remember I mentioned that earlier. Conducting proceedings during inquiry is IC's responsibility. Providing copies of statements to all the parties is IC's responsibility. Facilitating cross-examination, facilitating conciliation is IC's responsibility. Informing all the parties of their rights and responsibilities is IC's responsibility. Determination of compensation payable by the respondent is IC's responsibility. Preparing a detailed inquiry report is IC's responsibility. Now, this is during the inquiry. Now, beyond that, conducting quarterly review meetings for their own benefit, ensuring that IC's proceedings are going well, is IC's responsibility. Now, there is always a thin line that who will do it? Should employer do it? Should IC do it? It should be done by the presiding officer, or a presiding officer can nominate somebody within IC who can ensure that we are conducting QRM. Taking minutes of the QRM meetings is also within IC's responsibility. Now, is it mentioned anywhere? No, it is not. Ideally, the employer should not be part of the quarterly review meeting. So employer cannot take the minutes of the meeting, right? Employer should be outside of it clearly. Transcribing the statement, sorry, I just mixed up. The transcribing the statement during the inquiry, actually it should have come ahead, is IC's responsibility. So these are the clear roles or laundry list of roles of IC. Now, the main, okay, I have few which I've called out clearly for POs. The presiding officer. Presiding officer, as we said, is the senior most person nominated by IC who chairs the IC. Maintaining all documentation pertaining to the case is presiding officer's responsibility. Of course, presiding officer can nominate somebody to handle it. Sending out communication to parties during inquiry. I mean, it has to go from presiding officer's desk, right? Summon, any notice, any documents is presiding officer's responsibility. What I wanted to draw your attention primarily, and the discussion for today, is the overlap. Okay, aligning other organization policy with PoSH policy. Now, that is something which is very critical or very important. Now, dress code policy, code of conduct policy, harassment policy, discrimination policy, disciplinary policy. There are many other policies which are aligned to PoSH policy, right? Now, ensuring that it is aligned, while primarily policies is employer's responsibility, but from employer can, pick IC's brains to understand whether it is in line with the PoSH policy, right? Any diversity policies that we are looking at, hiring policies. So all that can be aligned. Reconstitution of IC. Now that is another big thing which is happening these days. It's been 8 years. So, it's the third wave of IC being changed. So this handover is becoming very tricky in many organizations. They're not sure whom to hand over, how to hand over. While IC can recommend people to be part of IC, but reconstituting as such is employer's responsibility. So there's a hand in glove here, and handing over the papers, handing over the documentation which PO maintains, or any download to the IC is clearly IC's responsibility. So this is a very close relationship that the employer and IC have to play. Creating awareness and sensitization, but if you look at the law, it says employers, but what should be the context of it? If there are any cases which has happened around maybe gossiping, right? So can that be handled? Can that be given as an input to the employer so they can add it to their awareness? So again, this is a very joint activity. Submitting annual report. If you look at submitting annual report, again, there is a clear indication that employer has to send it. But if you look at it, how will employer know how many cases was handled? IC, PO will have to write it down, right? So again, it's a joint effort. In fact, the PO writes it with the employer, because how many training sessions were conducted again comes from employer. So jointly you have to write the report, and one copy goes to the employer for their record, one copy goes to the district officer. Ensuring governance and constant vigilance regarding any law change, any policy change, any best practices which is coming up. Again, jointly, employer and IC have to come together and work on it. It cannot be that while employer will be very vigilant about any change in policies as such, I think ICs also should keep their antennas on to upgrade themselves constantly. They have this job for 3 years, and it's not only on paper, it is the true sense, and there's a lot of credibility, responsibility on them. So they have to keep the antennas they should attend such conversations so they can enlighten themselves. Assisting victim to file an FIR. Okay, again, while finally employer will be questioned, but IC being the sensitive lot, okay, being able to communicate with the complainant, again, they should jointly see how they can support the victim. Assisting in initiating any action by IC where the respondent is not an employee, he is outside of organization. Again, jointly IC and employer can do it. Formulating and executing an action plan for prevention of sexual harassment. Now, in the QRM meetings, there are many action points that come out, right? That we need to maybe. I was attending a QRM just yesterday, where one of the initiatives was that contractors need to be trained. Now, who will be training them? Should employer train them? Should IC train them? Jointly, we have to sit down, break our heads, and come up with a plan. Okay, it cannot be that you do it or you do it, then nobody will do it, right? So jointly, they have to work together on a plan and ensure execution. It can't be that, okay, employer, you do it, or okay, IC, not my problem, you do it. So it has to be jointly done. So this is what is the laundry list of what we thought are the roles and responsibilities of IC, employer, IC and employer together, presiding officer a little bit. Now, a question for this debate today is that do their roles overlap? Does any party report to any party? Can they question each other's workings? All right. With that, I start the panel discussion. I think it was too much of a monologue from me. I'll just take a pause and I will invite the two lovely ladies if they have to say any opening statement, anything that comes to their mind after looking at this, and then we would start the discussion. Who wants to go first?
I think Rashi should go first.
Okay, so yes, there are a lot of things which, the third part, Smita, which you were sharing about certain roles which goes to who, and it was constantly, a point which came up was that they need to be hand in glove. So that's the key factor, because the purpose and the end point for both, be it IC or the employer, is same, which is creating a safer work environment for the entire organization. And that's the key purpose. The entire policy is in place. That is why the IC has been created. So the best way forward is when everybody works in tandem. If they're working in isolation, nothing will actually happen. So that's something which has to be understood, that though roles are defined, however, the best way forward is when you work in tandem with each other.
Absolutely, Rashi. Well said. You have to work in tandem. It can't be that you do this and you do this. It's like, what can we all do it together? And it's a cause. It's such a beautiful cause. And we've got this law after so much of pull and push that we should be taking charge of it.
Smita, before my opening statement, I would like you to take back to the presentation which you were displaying. And I have 2-3 little legal glitch in that, which I want to explain before we go forward.
That there's always a legal glitch in what I present. Which slide do you want to share?
Go back.
Yeah.
Yeah, stay here.
Yes.
So once you have mentioned that interim relief, second point, grant interim relief, but we do not understand that IC in suo moto cannot grant interim relief. It is the complainant who have to make a written request to granting relief during the pendency of an inquiry. Then only a relief can be granted. We read it as if that IC has a power to grant relief during the pendency of any inquiry, but that is not the case. That has to come from the complainant, and a written request needs to come from the complainant to seeking any interim relief during the pendency.
Absolutely, bang on, Swati. Maybe that statement didn't come right, but bhavnaएं sahi thi. I meant that once the complainant requests for it in writing, granting it. See, many a times what happens is employer will say, we can't send her on a holiday. Sorry, you cannot grant this. But IC once says that you have to send her on a holiday. Employer has to simply execute it.
Right.
Okay,
right.
so bhavnaएं wahi thi. That is exactly what I wanted to say. Any other legal glitch?
One thing, determination of compensation payable by the guilty respondent. When we determine the compensation for the respondent, IC role also comes when there is a determination of compensation for a malicious complaint against the complainant as well. So likewise, if they can determine the compensation for the respondent, they can determine the compensation for the complainant as well, or any false evidence produced by the witness as well. Law envisage even the punishment for any malicious complaint or false evidence or false witness or anything. So the compensation payable to the respondent and the complainant can be determined by the IC, and that is a very important role of IC, because that there is a complete section to it for a malicious or false complaints. And nowadays it is also a case that there are a number of malicious and false complaints as well.
Yes,
so
absolutely, bang on. We will add that to the laundry list. Thank you, Swati, for that.
Yes. So if in my words, there is no overlapping, I guess. The employer is a main umbrella, and the IC, apart from that, when there is a complaint came from any complainant, then you have to form an inquiry committee. IC has the responsibility to form an inquiry committee as well. The IC per se cannot conduct the whole inquiry and proceeding in itself. They first have to form an inquiry committee, and a presiding officer along with two member can be a final quorum for that. The quorum for an inquiry committee is 3 members. 2 members and 1 presiding member can be the quorum for it. So, just 1 second.
Yes, Swati, the minimum quorum to conduct an inquiry is 3 members, where the presence of the presiding officer is mandated. All inquiries, presiding officer has to be there. Yes. And it was actually something which was asked, that what if all IC members are not available at the same time? That is why this particular thing is there, that even if minimum 3 members, including the presiding officer, are present, then that particular day of inquiry can be done.
Yes. So you need to form an inquiry committee as well. So the employer is a bigger umbrella and IC is just a wing to it. So employer is much more responsible for any roles and responsibility provided in the PoSH Act 2013, in letter and spirit. This act is formed for providing a work space and for prohibition, for prevention and redressal of any complaint came from any lady in your organization. When a lady comes to your organization, she should feel safe. She has come there to work. So it is a primary responsibility. If you understand the law in letter and spirit, that is the major responsibility is of employer. And the IC is just a wing to it. So other than overlapping, that they should conjoin their hands and then work together to take up the law in the letter and spirit. You're on mute, Smita.
We can't hear you. No, something has gone off with your audio. No, not even now. Yes, now we can.
Okay, awesome. I don't know what happened. All right. So perfect, Swati. Swati, I think that these are some really important inputs that you have given us, and we will make a note and make this document very exhaustive. Actually, it is a working document. It will keep changing as much as input we start gathering from each one of us. There are a few interesting questions in chat box also, but we'll come to that. Before that, I have few questions because we are speaking about recommendation and management. Swati, this question is for you. What is the legal force of a recommendation? Do you want to first start with recommendation and what is the legal force of recommendation? That's after.
See, Act provides that one recommendation has come from the IC, then employer is bound to implement that recommendation. And what recommendation is in the action form provided in the 3 sections of the PoSH Act 2013. Section 12, Section 13, and Section 14 deals with that. In the pendency of an inquiry, when a written request has come from a complainant, then action can be recommended by the IC. And in Section 13, at the time of inquiry, action can be recommended by the IC, and at the punishment for false and malicious complaint, then action can be recommended by the IC. Now, if you ask me that what is the legal viability of a recommendation given by an IC, then I must tell you that there is a complete section to it for punishment if any action has not been performed by the employer. Section 26 deals with if you have not performed any action which has been recommended by the IC, then employer, there is a penalty for it around that can extend to 50,000 rupees. And secondly, a very important thing, if you commit this offense again and again, then the twice amount of the penalty which was first you are convicted to, and secondly, very important thing, that your license, your registration can be cancelled. So if you ask me that what is the legal viability of a recommendation given by an IC, then it is a huge, because there is a punishment in terms of monetary compensation, monetary punishment, and apart from that, for the business activity you are carrying on, that can be cancelled. And that licenses for any business activity you're carrying, that can be licensed. So this is the legal importance of a recommendation given by the IC to an employer.
That is quite powerful, and I hope all employers are listening to this. Any input from your side, because many a times ICs are taken by the way. Okay, y'all do it. Aap apna kaam kar lo, hum dekh lenge types. So. That was very forceful. I'll record that piece and play it every time I hear anybody saying anything otherwise.
One important point over here is also that one should always remember, once the IC is formed for the inquiry, they have the power of civil court, and that needs to be respected. So what Swati said, once the IC recommends a set of penalties or the further course of action, the employer is bound to follow them, because they need to understand IC is not just a group of employees sitting there. They have a power under the PoSH Act. So that also needs to be understood.
See, I would like to add one thing. For power of civil court is pertaining to the adjudication of complaint, Rashi. So
for the inquiry, yes, for the inquiry.
For whole complete inquiry and adjudication of complaint to someone, to call for witness, to call for evidence, and then maintain the confidentiality thereon. So for adjudication of complaint, but once the recommendation has been given and now the time of implementation has come by the employer, then it also have a very, very, very legal penalty behind it if you do not implement it.
Yes. So that is what I was trying to impress upon, that if just for the inquiry, for doing the entire, the complaint and the process properly, if the Act gives the power of civil court to the IC, imagine the seriousness of the Act itself to ensure proper inquiry. An inquiry has to lead to some recommendation if it is going in that direction, and then the employer is bound to follow that. So it is to understand the seriousness of the recommendation made by the IC under the Act.
Right. Absolutely.
Okay, awesome. I think that has come up very forcefully, and that should be used across. Okay. My next question, Rashi, is to you: is management accountable to IC? Should management, accountable to IC for recommendation? Should they be coming back to them? So, what do you think is the status of management here?
So when, in an organization, there are people who are specialists. So you always go to them, department heads or departments have specialists, and you may have a particular point of view, but you go to the specialist for the final process which you would like to follow. Similarly, the IC here becomes the specialist. They have been formed with certain ideas in mind. I'm sure when the employer was forming the IC, they had taken those things in consideration. That's why the presiding officer has to be the senior most women employee. And there are other things which obviously the organization looks at. There are trainings which are done, which is the responsibility of the employer, that the IC gets the due knowledge share when it comes to understanding their role. So obviously they now are completely ready and trained to do the things. So when they are making a recommendation, bound is a strong word, but I will use that. Employer is bound to follow it. And in case of implementation, I do believe that if they're finding some difficulty, yes, they can go back to the IC for asking them a way forward around it, not to question the recommendations.
All right, I'll give you a real instance. One of my colleague called me, ex-colleague, she was working in an organization and she was the HR head of this organization. She called me that, there's an outcome from IC and I do not agree to it because the outcome is is not up to the standards of that organization. Okay, the recommendation is very mild. So can, as a management, we tell them that this is too mild, please give a very severe outcome and reprimand the person severely. So I want to turn it down or ask them to redo this. So what do you think should be our recommendation to these people?
So, well, if I turn around the question, Smita, it could be the other way around also. That, IC has come up with a recommendation and we as a management think it is too harsh and we would want the IC to, tone it down a bit. So then it is kind of opening a Pandora box. So probably if the employer thinks that the recommendation handed out by the IC is mild, they may need to think back and see whether the IC formed is in the correct spirit or not, 1 point. Otherwise, they should follow the recommendation of the IC.
Okay, all right. Swati, any input from your side on this?
No, I think Rashi has covered it really well. Just one thing that whether management can question the IC recommendation, they cannot, even if they question it, they cannot change it. And once they recommend it, they have to implement it. So law is given that you have to implement it, and there's no sub law is given or subsection is given that you can question it or you can recommend it back and forth. So the recommendation given by the IC, only foundation is given that you have to implement that within 60 days and nothing else. So you may question it, you may alter it, you may try to alter it, but the final recommendation will be, which will prevail, will be of the IC only.
I have a point here, if I may, if I'm allowed to pose.
Who's this?
I'm Madhvi. I'm a PoSH trainer from Hyderabad. Is this forum available for somebody to raise a point, or it is just as a listener we have to be participating?
So Madhuri, I recommend that you put your question in the chat, or is it relevant to what we are discussing right now?
What you're discussing as of now.
All right, sure then.
So the question is that suppose the recommendation is made, and as you said, the management finds it very mild, because the management has a set of HR policies or whatever policies where they feel that certain actions, when done, end up receiving this kind of severe penalty or punishment, whatever. And if the recommendation given by the IC is much calmer or much milder than that, then the recommendations must be considered, but the severity can be increased. That window, that space, it cannot be given. Because when IC is constituted, I feel IC has been given that power because of the authority and knowledge of the subject. So during the entire proceedings, the mental trauma of the victim or the psychological impact on both the parties, all these are assessed gradually in all stages of the proceedings. And then they come up with this recommendation. So nowhere can the management have a free hand of increasing the severity, or the severity is what I opine, but that is what my view is. But yeah, if there is anything different from that, I would like to be corrected. Thank you.
Thank you, Madhvi. I think even Swati and Rashi were on the same line, saying that there's a reason why IC is constituted. IC is constituted because of the credibility of them being in the organization, because of the culture that they want to instill within the organization. And if the employer feels later on that, okay, they have not done what they are supposed to be doing, maybe they can go back and then have another round of conversation why they are thinking what they are thinking. Okay, but clearly IC is an autonomous body, and they should carry on with and they should go ahead and simply implement the recommendation given by IC. Thank you, Madhavi, for that. All right, so I have a question for Swati. If respondent has left the organization, okay, this is a problem that comes all the time. Okay, what kind of recommendation can be given?
Okay, so if he has left the organization, there are
Sorry, you are muted somehow. I don't know.
okay.
Sorry.
No problem, no problem.
Yes.
Okay, am I audible now?
Yes.
Okay, so the recommendation with regard to when the respondent has left the company or has resigned while the inquiry or at the inquiry of the complaint. See, the recommendation even after when you leave the organization, there's a determination of compensation based on the several factors which is given in the law. So if you determine the compensation, then a respondent either leave it or state has to pay it. If you can't take it from his salary or his wages, still the employer has the responsibility to get the money, get the compensation which has been determined by the IC from the respondent. Secondly, apart from the compensation, apart from a sum of compensation to be taken from the respondent, there are you can ask him to do a community service. You can ask to get him a counseling session, or you can. So these are the kinds of recommendation which can be given even after the respondent has left the company. If you determine the compensation by IC, then he has to pay it. There's no window given in the law that if he leaves the organization, then whether you can ask for the compensation or not. No, if you determine the sum based on the several factors, then he has to pay it. And apart from that, community service or counseling session that can be given to the respondent.
I have a little weird, extending this question. Can we, if he has joined an organization, another organization, can we go to that organization and ask them to execute anything, like maybe, not give him promotion for next 3 years or something like that? It's a little out of the box.
See, I welcome that question. Withholding of promotion can be done by the employer. So if you are withholding a promotion, you cannot ask another employer to withhold his promotion. then there are two employer came into existence. So being an employer, you can withhold the promotion. But yes, this market works on a mouth to mouth. If you say that this person we have a sexual complaint, or a complaint against sexual harassment against this person, then that word, but you can't bound an employer to withhold his any promotion or anything like that.
Got it, Swati. I was just being too ambitious. Actually,
Too much rage against the respondent, Smita.
No, not rage. I'm just saying that we are ensuring that we are covering from
yes,
totally not rage. I'm just saying that can we work as a community rather than working in boxes?
Right,
Can we work as a community and serve the purpose? That was the idea.
Absolutely.
Okay. Rashi, anything from your side?
Actually, yes, it's a very interesting question, Smita, because when a respondent has left the organization, so there are three scenarios which come up over here. So the respondent has resigned and left, joined another organization, and the complaint has come after that. So that's scenario number one. Now the respondent is no longer your employee. So what do you do in that regard? Second is that during the inquiry, a complaint has happened, but during the inquiry, the respondent resigns, or the respondent has resigned, and then before his last date, the complaint is made. So these are the three scenarios which I see over here. And the first one is most difficult when the respondent has already left the organization. However, since the complaint has happened during his stay in the organization, I believe, I don't think law says anything specific about that. However, for the spirit of the entire process, I think the HR of the organization should reach out to the respondent and tell him that, hey, this thing has happened. You need to respond to it, and this is the process. Follow the same process. In case the respondent is resistant or is not responding, the responsibility of a fair inquiry is on you as the IC. Probably you can tell him that, obviously Smita can correct me in that case, you can then get in touch with the IC of the organization he has joined for this particular case. Obviously, I don't think the law talks anything about that, but this in a way of best practices. In the other two scenario, where either during the inquiry or at the beginning of the inquiry, the employee has resigned, you could always ask the respondent to wait till the inquiry is over. You can push their release date and also attach their FNF to the resultant or the inquiry का जो भी result आता है, to that you can attach their FNF. Then they are bound to participate, because a lot of times we've seen that once an employee resigns, their interest in that organization lowers because they are anyways exiting. You find very few employees who work to their maximum potential till the last day of their employment. So, these are the steps you can take because the person is still part of the organization. You could extend their last date and say that you will not be released till this particular case is resolved, and you have 90 days. As an IC, you can try and fast track it, because you cannot penalize because a complaint has been received, nothing has been proven yet. So you cannot penalize that person also by delaying the process. So from the IC's point of view, you can fast track it. However, hold the respondent till the inquiry is over. That's my take on this.
Yeah, I think Swati, you have a point on not...
yes. Yes. I'm not sure legally, because PoSH Act doesn't provide that, whether you can extend someone's resignation, because that is governed by the contractual agreement between an employer and an employee. Then PoSH Act or IC, that does not come into the picture. So an employer's resignation and notice period service, that's governed by the contract agreement done at the beginning of the at the time of the employment, along with the HR policies which he has signed to adhere to during the course of his employment. However, in PoSH Act 2013, you cannot by getting the power of PoSH Act 2013, you cannot extend his resignation. See,
So that's not extending the resignation, Swati. You are, kind of, taking in the resignation of the person, and you can always extend their last date depending on the lot of, what handing over the employee has to do. And a lot of organizations do that, even under the HR policy, that the handover is to be complete in all respect, not just in the specific job description area of that particular employee. And a lot of times what happens is that there are clauses that organization can decide to extend your stay in the organization in case you resign based on the sheer discretion of the HR, or they can say we can change our policies in retrospect over certain things. And third thing, the most important thing for any employee, your full and final settlement always is very important. Lot of organizations, what they do, the moment your resignation is accepted, not when you have resigned, once your resignation is accepted, and say, for example, you have 2 months notice period, you get the salary of those 2 months after you have left the organization. So you stop receiving your monthly salaries. So you are putting that kind of money at stake. So those are the kind of things you can put forth in front of the respondent as a way to get them to cooperate for the inquiry.
One thing I would
Swati believes that that is arm twisting.
It's actually trying to get a fair trial. Like I said, once a complaint has happened, we are not saying the respondent is guilty. It's just that we want the respondent to participate for a fair inquiry.
I agree with you, Rashi. Reason why
the questions are coming, and I want to clarify one thing, that what your salary is and what is the determination of compensation is totally different thing. The determination of compensation will be the factors which will determine the compensation are only 2 factors which is given in the law. One, the income and financial statement of the respondent. For example, my family is very well to do. I'm just doing a job to, a 9-to-5 job just to pass my time. My financial status would be maybe like very good. I'm still doing the job. So for determining the compensation, the financial statement and your income is important. Secondly, feasibility of such payment. It does not depend upon the what salary you are drawing. Even if you are extending the resignation, if you are extending the service period in employment, to correct my language, then you then you may not be there's a thin line of demarcation between both of them. हम ये नहीं सोच सकते कि सिर्फ हमने हमारा जो salary जो हम we have to deduct the wages and deduct the compensation and then give the compensation to the lady. You may determine the compensation independently.
Attaching the salary, I was just saying that that is a way to get the respondent to cooperate in case of resignation. You are nowhere saying that I am attaching your salary as a penalty. I'm just saying your full and final as an organization is with me, and you need to cooperate for this inquiry for us to process the FNF in due course of time. That's all.
We just taken it, we have kept a lien of it. So then this person behaves in a particular fashion. So it's just that.
I rest my case by saying that you are HR and you deal with practical problems. So whatever works in best scenario for a lady who has filed a complaint. But if you ask about legal, metrology in this, then I must say that there is no such legal provisions assisting what you are saying. However, being ladies and being empowered women and being HR, you may take the best course to take up this law in letter and spirit, whatever the best course is.
All right. So there's one important question. I know we are like 4 minutes left, but there's something really important. Can IC continue to be involved once the report has been shared with the management? I think Suchitra Date also asked that is it management's responsibility to let us know that they have implemented? So can we continue to be involved? Is the question. Because there are times where we send the report to management, we give a copy to both complainant and respondent. Sometimes it goes in a black hole. We still see the responding loitering around and the complainant loitering around. We don't know kya hua unke saath, you know. So is it management's responsibility to inform IC? Can we stay involved till the outcome, till the execution happens? That's one of the important questions.
Tashi, would you like to take this question?
Yeah, sure. So this is very interesting question. So what happens is IC has made the recommendation. They share 3 reports, one to the employer, one to the complainant, one to the respondent. Now there are 3 people who are watching the employer, whether they implement this or not. So it is in general best practice. The law doesn't say that. It is a good idea if IC does stay involved in spirit. However, the employer needs to know that complainant has a copy, and if the implementation of that recommendation is not done within 60 days, the complainant has the right to go to the tribunal for non-action. So the employer needs to understand that in spite of, even if the IC is not responding to that, the complainant or the respondent can. Yes. So that's something very important for the employer to remember. So it is in their best interest to act on the recommendations given by the IC.
Absolutely. Even the complainant can file an appeal within 90 days. That is, if she has any grievances, if that is not action is not taken against for the respondent. So and even apart from that, you have to file an annual report to the labor department. In your annual report, in the director's responsibility statement, you have to put up, due to confidentiality reason, you will not put the name of the complainant and the respondent. However, you have to put that if you have received the complaint, you have resolve the complaint within 90 days of the receiving it. So this is what you have to put in your annual report return and in annual report as well under Companies Act. All
right. So awesome. So then they have to ensure that they respond. According to me, it's a best practice. Once you implement, send a note to the IC saying that we have implemented your recommendation. This is FYI. If they have given a warning letter or any termination order, send a copy. The file will be complete. Okay, it will be like, okay, there's a copy and the file of presiding officer will be complete. But it is very loosely written in the law. Law doesn't mention that it is required, right? But I think it's a best practice to complete the circle to do that, right? So I'm sorry, I know I said last question, but one more last question.
Currently, Smita, even Bombay High Court had judicially pronounced that even the sexual harassment cases or such matters will be heard either in camera or in judge's chamber. Orders are not to be passed in open court or should not be uploaded on the official High Court websites. So you have to maintain the confidentiality. So even if you have not implemented, the employer cannot go around and display that in the public. You have to maintain the confidentiality of the complaint throughout. There is no time limit for that you have to only maintain till the adjudication of complaint or the implementation. You have to maintain the confidentiality throughout. So if you have to maintain the confidentiality, Smita, then you may not utter to the next respondent or the company where he's working that there's a complaint which has came against this person, because you have to maintain the confidentiality of the complaint.
Really? Because we use that, what happens to the background verification? You will have a person, perpetrator who is terminated from this organization and joining some other organization.
But that must be written in the FNF, or that must be written in the termination letter. You will not be putting the name of it, the complainant, or the whole inquiry process and how it has. Uh, yes, but yes. So that
All right.
needs to be.
So one last question, okay? What happens? There are times when management in IC, we say, okay, terminate this person, but management goes ahead and asks the person to resign. So what is repercussions of acts there? Are there?
I didn't got the question.
The question is, there are many a times IC says that this person needs to be terminated, the respondent. But management are very scared of termination. The word termination is like a taboo. They prefer taking resignation from the person. They'll say, oh, you don't resign, we will terminate you. And the poor fellow will resign and go away. And they are happy, okay, close case. But is it right?
I think Rashi is the best person to answer this, because it's a moral question, more of a legal question.
Oh, well, Smita, the idea again over here is, yes, the IC has, when they are recommending termination, what they're essentially saying is this person should not be part of the organization, right? So even if the management is saying you resign and leave, a lot of times in case of code of conduct or HR related issues also, certain employees are found, financial frauds happen, a lot of things happen. So a lot of times employees are told to leave by giving a resignation instead of terminating them. So termination as an organization is very judiciously used most of the time, because the idea over there is not to spoil the person's career forever. Because if you're terminated, probably you will not get an experience letter. If you get that, it would be mentioned in the experience letter. So that kind of harms the person's entire career. He's kind of doomed for life. So to save that, the person is asked to resign so that rest of the things can be done. At least he has a recommendation letter going forward, and probably with that, the person learns their lesson.
I absolutely believe in rehabilitation, Rashi. I feel if you don't rehabilitate people, we will have people doing negative things.
Absolutely.
But I think then if we say it's okay that IC has said termination and you're going and asking for resignation, you are not complying by IC's verdict. Okay, you are downplaying their recommendation, right? And I think here, if anybody challenges, management could be in question. Right?
Absolutely, they can be. I agree with you on that.
So either and again, asking for resignation, I don't think is legally right. You cannot ask. Resignation has to be given by somebody. Somebody does not want to work with the company, has to resign on their own. So
but in the organization, it happens all the time when you ask employees to put in their resignation instead of terminating them. So it's a common practice, though not
I agree with you. I mean, I'm also an HR person, and I know how many such conversations we have also had. But again, putting it down in PoSH report and saying ask for resignation or ask the employee to resign, I think it will be an issue for IC also in their report, and I think it will be an issue for management also. I think if you do not want the person in the system, it should be termination.
Resignation is a personal right. It is not a right of the management. The management has a right of termination, and an employee has a right to resignation.
Correct.
So the employer cannot take right of the employee. Absolutely. Because employee cannot terminate the employer. He can only resign. So this is how it works legally.
Absolutely, that is how it works. I am going to Madhvi says termination means only termination. But if
offense, reading those, so I was thinking, I think I am the soft one over here.
I don't worry, I am the soft one. What I would prefer is, even if the person is terminated and next organization he's joining, and if his work has been good enough, that person should be re-employed. I mean, employed by another organization. In fact, I had a case where a person who was terminated for PoSH the HR head called me and said, I'm getting a profile of a person who was asked to go from his organization because of PoSH. He's a great fit. What do we do? I said, you cannot punish the person twice for same offense, right? Go ahead and hire him, right? But keep a vigilance. Tell him that, listen, you've been terminated for PoSH. No panky business here. If you do anything, you are under suspicion. Sorry, we are biased, but we will be biased. So that is, and I completely believe in rehabilitation. In fact, termination will come if the person cannot be tolerated in the system, is my recommendation in many of the cases. I do not recommend termination at all. I feel if you cannot, rehabilitate the person, then you're throwing that thing back to the society, right?
Totally.
You're throwing that person out. So it needs to be cured and seeded back, is my thought. Okay. I'll quickly go through questions. I know we are like running super late. The questions are, many times case is disposed of outside the court by give and take money. No proper justification why. So Swapnil, it is not IC case. I don't know if IC cases happen. I have not come across any such case. Maybe they are too scared of me, so they don't come with this give and take. I would want to hear from Rashi or Swati if they have come across anything.
So again, court is a different ball game altogether. IC is within the organization, so it's as simple as that. So this particular question is not specific to when the IC is in picture.
Yeah. No, so I think he meant to say that if a complainant has made a complaint and then she goes behind IC and kind of settles it with the respondent and then kind of withdraws the complaint. So that came to my mind. I've not experienced any such behavior.
I have also not experienced it. And as far as the act is concerned, conciliation happens before the inquiry. Correct. The right, even for the complainant, the right for conciliation is before the inquiry is started. Once the inquiry has started, the conciliation process option is no longer there.
Yes. And there is no monetary settlement which can be given in the conciliation.
Yes, conciliation cannot be a monetary settlement.
Yeah. Such companies have exit interview clause too, which needs to be cleared. Only FNF and other things follow. Okay, this is a statement. In case FNF is settled and there is compensation arises, what is the solution?
Even, shall I?
Yes, please.
Even if FNF is settled and there is a compensation, then the respondent is bound to pay the compensation. Law provides that you have to pay the compensation and whatever has been determined by the internal committee. That's what I explained, that there is a difference between salary and wages and deducting the salary and wages and then another thing is determining the compensation. These are two different things totally.
I think you should write a blog on this, Swati. We'll have a separate conversation on what is determination of compensation. We are not yeah. IC is a statutory authority under Act. Recommendation has to be implemented by the employer. Okay. Is it mandatory that external members inform that recommendation given by IC are implemented? Yes, Suchitra, we spoke about it. I heard that question earlier. In case of no evidence or no witness, who to consider the case? Who to consider the case? How to consider? I think you're saying how to consider. We can't consider anything. If you can use preponderance of probability or circumstantial evidences, these are two things that you can look at. Otherwise, cannot be proven. And many cases fall in that bucket, which I'm really sad. Any Rashi, Swati, anything you want to add here?
So one more thing.
Please, Swati, go ahead.
No, Rashi, please go ahead. Please go ahead.
No, so in the such cases where there is no possibility of any kind of proof or witness, so sometimes we do realize that what we need to do is counsel both the parties, because when you can't prove, you cannot have a set of inquiry, because then it will come under the radar of being biased. So in such case, the best idea is to counsel both the parties and let the case close at that.
even if I want to add one thing, that law provides so much window to a complainant that just mere an ability to substantiate your complaint, or you are not able to provide the adequate proof, does not attract the provisions of malicious complaints or false evidence against you. So even if the complainant is not able to substantiate her complaint by evidence or by witness or by any other things which may be prescribed, then also you cannot take an action of malicious complaint against her. So vice versa, you have to adjudicate in the best manner possible, considering the opportunity of being heard audio alteram partem to both the parties.
So Swati, I'll tell you exactly the same situation I am currently in, where the case is leading to cannot be proven. And now respondent is saying, try it for malicious intent, and we can't find malicious intent. He's saying if it cannot be proven, then it is malicious intent. So explaining to him that what is malicious intent is taking all our energy.
So this is where counseling comes in, Smita, where you will have to sit down the respondent and, tell them, because, sometimes they're so angry. How could they do this to me? So you have to, work with them also on that in such cases.
I want to add an quote to very, very, very important judicial pronouncement which has come up recently, and which is really important, which is against what you are saying, that whether how to prove that or anything. What happens, people, they are in a romantic relationship, employer and employee, and then there is a departure, and then a person complained against one another. So Tamil Nadu court has said that personal feud, misunderstandings, and not getting along with male colleague would not constitute the sexual harassment. If you're just not just getting along with male employee, then it does not constitute a sexual harassment. Apart from that, Kerala High Court also says that a situation of discrimination on the basis of sex, if there is no express or implied sexual advance, sexual undertone, or unwelcome behavior which has sexual tone behind it. So you cannot say that a person is, there should be a sexual tone to fetch the case of sexual harassment.
Absolutely, bang on.
And one more thing, what sometimes I have also been into situations where that moral policing comes into your mind in this kind of instances. So I would like to say, even Delhi High Court has said moral policing is not the job of the management or of IC. Any consensual relationship among the adults would not be a concern of the management or the IC.
Absolutely.
So long as if the
None of
relationship does not affect the working and the discipline of the organization, it is not contrary to the rules and code of conduct binding on the said employee. IC cannot make comments on the personal conduct of the parties, and the IC's jurisdiction would be restricted to the allegation of sexual harassment, and whether is complaint made out of that or not, to only that effect. You cannot make a personal comments as well.
Yeah, you can't be judgmental about a person, as simple as that, or have biases.
Yeah,
Yes.
so I remember an instance where somebody whom I know and was looking at the WhatsApp exchanges between the complainant and respondent, and she turns around to the complainant and says, with all this exchange, I think, you all should have been married by now.
Even married relationships, Smita, there are instances when a married couple, there is extra marital relationship in office, even of a husband or even of a wife. The both employer and employee are in, have their respective marriages, and that get along into a consensual relationship, and then later on one files a complaint against one another. So in that,
we are not moral policing. That is not our business. Two consenting adults can do anything, which is not our business. We have to not get into all these things. It's not our jurisdiction, if I have to use that word.
Totally, absolutely. That's their personal business.
You cannot comment on the personal conduct. अरे आपने ऐसे क्यों किया? आप तो शादीशुदा हैं, ऐसे कर दिया.
You can't.
Yes, you can't make those, because I have attended some ICs where people tend to make those kind of comment that you are married and you know that you are married and still you're doing this. So that kind of
that stems from our unconscious biases that a married person cannot be involved in other relationship. Okay, this stems from our unconscious biases, so as an IC we should know our biases, our unconscious biases. So that's a different discussion. And
That's why I say PoSH trainers have a lot of work to do.
a lot of
Because this is what we tend to teach during the entire training. Also, gender bias is such an important topic of being judgmental coming from our own cultural background. A lot of biases happen, not just gender. So we have to be careful about these things once you're part of the IC. And even when you're working in an organization with people coming from multicultural, you have to understand these things and not get into the zone of moral policing.
Absolutely. I think bang on, we have a lot of work to do, and we getting into moral policing is not our business. There are more questions flowing in, especially I think, Swati, you'll have to conduct one session on compensation. I see a lot of questions, and we are like, what I will do is, we anyways have recorded it. I will download these questions and send it to you specifically related to compensation. We will write back to these folks, okay? Thank you very much, because I'll have to take, it's like what, 16 minutes over our scheduled time. Thank you very much, Swati. Thank you very much, Rashi. This is the first time ILA and KelpHR are doing this session only with 2 panel members. The reason for getting 2 panel members was so that we can pick few brains at a time and not have too many brains. So, so we have concentrated discussion. But I realized that there was so much to talk that we spilled plus 16 minutes into the conversation. It was a great, engaging conversation for me. I have so many things to learn from 2 of you. Thank you very much. I will be closing this conversation. Rashi, Swati, any last closing comments from the 2 of you?
Thank you so much for giving me this opportunity, Smita. So, and thank you so much, Rashi, for being such a co-panel member, such a nice co-panel member. And I have whatever knowledge I have tried to give that in 1 hour, so we can have, yes, you're right, we can have one more session of compensation, because it has so many of gray areas and this moral policing thing as well. So yes, we can have one more session about that. And thank you so much for giving me this opportunity. Thank you, Rashi. Thank you, Smita.
Thank you.
Thanks a lot, Smita and Swati. Yes, it was fun session. I had so much to learn. Now, compensation is definitely something for which I'm coming to you, Swati, very soon, because there are a lot of things which happen over there. So definitely going. And Smita, I am going to be in touch with you for a lot of things related to this. And I have so much to learn from you also. Thank you very much for this opportunity.
All right. Thank you so much. It was very nice Thursday evening. We close with a big bang. We are live on LinkedIn. You can check us out if you missed out, or you can, pick in more questions, add more questions to us. Okay. Thank you. Thank you all participants for staying with us for so long. I will close the conversation right now.